14. A crucial and often misunderstood aspect of the framework is that when assessing corporate actions, it is the material impact of corporate actions on the current and potential protection of human rights and the conflict-affected context itself that matters, and not the degree of diligence exercised or the degree of negligence. In other words, conducting this due diligence will not absolve a corporate entity of responsibility. What matters is the human rights impacts and the actions taken to avert or address the risk. 15. Correctly identifying the violation in question is therefore crucial. This means corporate entities must consider whether specific human rights violations may also be constitutive of more structural and systemic violations of international law. According to UNGPs, the severity of the human rights impacts will determine their responsibilities and the sufficiency of the steps taken to prevent, seize, and remedy the serious violations. For example, a corporate entity may be contributing to home demolitions and forced displacement. However, in a context of settlement expansion or more structural crimes, the corporate entity's actions may also be directly linked to the maintenance of apartheid, racial discrimination, and genocide, or contributing to those violations when systematic forced displacement is a constitutive component of these crimes as they unfold. They are also inherently contributing to the violation of the right to self-determination. 16. Additionally, the complexity of expected HRDD process and the urgency with which corporate entities must act is proportional to the scale, scope, and irremediability of the violations occurring. In situations where there is clear evidence of ongoing, widespread human rights violations, the corporate entity must treat the risk of involvement as a legal compliance issue and, in the most extreme circumstances, cease operations in the state in question. Heightened HRDD enables corporate entities to anticipate escalations in the violations and take the requisite action before those violations materialize. Failure to do so affects the degree of involvement and the extent to which their actions will be considered sufficient, impacting liability assessment. Thus, a corporate entity directly linked to home demolitions and failing to terminate its relationships will find itself contributing to that violation, carrying greater responsibilities. 2.3. When responsibility may entail criminal liability. 17. Failure to act responsibly in line with international law may implicate corporate entities in more serious violations, giving rise to criminal liability for the corporate entity and/or for its executives. 18. Drawn from the legacy of the industrialists' trial at Nuremberg, corporate accountability for international crimes is based on a recognition of the critical role the economy plays in times of war and conflict, and the fact that corporate entities may be involved in heinous violations of international law constituting international crimes. 19. Individual executives can be held criminally liable for the actions of their corporate entities, including before the International Criminal Court. While increasingly, corporate entities themselves could also face criminal liability as a result of the emerging crystallization of customary international legal principles. This includes some domestic jurisdictions which attribute criminal liability to corporations, and a growing body of treaties enshrine criminal liability of legal persons, which means that under international law, corporations can be criminally liable for specific crimes, including genocide, apartheid, financing terrorism, organized crime, and corruption. 20. The conduct of corporations and their executives may entail direct criminal liability, but more commonly constitutes complicity or aiding and abetting liability. This may involve instigating, moral support or abetting, furnishing aid or assistance for, or procuring the means for the commission of a crime, or the creation of conditions necessary for atrocity crimes to occur. International tribunals have generally found that criminal liability for such forms of complicity, A, can be established where the aid or assistance has a material effect on the commission of a crime, and B, depends on the knowledge possessed by the entity executive of how its services or activities will be utilized and the effect on the commission of the crime. 21. In other words, it is not necessary to show that the entity or individual intended the particular harm. It is sufficient that, in providing logistical, financial, or operational support, they had actual or constructive knowledge that the principal perpetrators were engaged in a given crime, or, in the case of prosecutions before the ICC, acted for the purpose of facilitating the commission of such a crime. Financial and managerial control over a corporate entity engaged in the crime is sufficient to establish the basis for individual criminal responsibility. Jurisprudence has confirmed that corporate actors cannot avoid accountability by claiming that they were merely fulfilling commercial contracts. 2.4 Mechanisms of enforcement. 22. This international framework is enforceable via a range of mechanisms, particularly at the domestic and regional levels, established by states in order to fulfill the legal obligations outlined in Section 2.1. 23. For many corporate actors, a key incentive to uphold practices that respect human rights is the risk of reputational damage arising from their involvement in human rights violations and international crimes. The UN database, see 3.1 below, for instance, has significantly promoted awareness of corporate responsibility in the OPT and contributed to investment decisions. 24. An examination of all legislative and policy mechanisms adopted by states is beyond the scope of this report. In many jurisdictions, corporate violations of jus cogens norms, customary international law, international criminal law, and international human rights law are enforceable in courts, while in other domestic criminal laws, tortures and negligence laws and contract laws provide useful mechanisms for victims. The UNGPs can and should be consistently used to provide a normative lens to assess corporate conduct and establish legally relevant facts. 25. Examples of corporate accountability for violations of international law include in the UK for toxic emissions from a subsidiary Iran copper mine, in the Netherlands for the supply of nerve gas to Iraq, in France for payments to armed groups to keep a cement factory running, and in Sweden for using the military to secure oil fields in Sudan. In the US, a civil suit under the Alien Torts Statute, under which US courts can hold American corporations accountable for violations of the law of nations, led to settlement with a US oil company for its complicity in violations in Myanmar. 26. Where a corporate entity profits from actions that constitute an international crime, e.g., a war crime, genocide, apartheid, or an act of aggression, this may also form a predicate crime for an offense under money laundering and proceeds of crime legislation that exists in many domestic jurisdictions, which, if successfully proven, can infect all corporate dealings along the supply chain, such as provision of insurance, tech services, legal accountancy, and banking services. 27. Domestic human rights due diligence laws now exists in several states, including France, Germany, Norway, and Switzerland, and the number can be expected to increase across EU states following the adoption of the EU Directive on Corporate Sustainability Due Diligence in July 2024, subject to proposed amendments. These laws establish mechanisms for supervision and enforcement through injunctive orders and effective, proportionate, and dissuasive penalties. They are often complemented by regulations applicable to particular sectors, such as dual-use cyber surveillance items, forced labor, and non-financial reporting entities. 28. The OECD guidelines for multinational enterprises on responsible business conduct have opened new opportunities for scrutiny. These require all 25 adherent states, including Israel, to establish national contact points and CPs to promote the guidelines and create a non-judicial grievance mechanisms allowing NGOs, trade unions, affected individuals and communities to lodge complaints about the direct operations or supply chain of companies operated in or from an OECD country, and to receive a mediated outcome for final determination with recommendations. 29. Where direct remedies are not available against corporate entities, it may be possible to hold states responsible for failing to comply with their obligations vis-à-vis corporate entities within their jurisdiction. 3. Applying the framework to the occupied Palestinian territory. 30. In the case of the occupied Palestinian territory, corporate entities have been on notice for decades regarding the widespread and systematic nature of the human rights violations perpetrated there. Proper human rights due diligence would have identified the risk of corporate entities incurring responsibility for such violations well before the catastrophic events that have unfolded since October 2023, all the more so if the required heightened processes were followed. 3.1 An inherently unlawful context gradually exposed. 31. Since 1967, Palestinian and Israeli human rights groups, the United Nations main organs as well as UN treaty bodies, special rapporteurs, investigative committees, and major international NGOs, including Human Rights Watch, Amnesty International, Save the Children, and Oxfam, have systematically documented the Israeli occupation's many violations, including the economic structures that sustain it. 32. In its 2004 advisory opinion, the ICJ found that Israel's construction of the wall in the West Bank, including East Jerusalem, violated peremptory norms of international law, including the right to self-determination, the prohibition of annexation, and obligations under international humanitarian and human rights law, including the crime of forced displacement. 33. The 2004 advisory opinion laid the foundation for civil society responses such as the BDS campaign and initiatives by other actors who have mobilized around the principle that those who profit from occupation should be held accountable. In response to mounting pressure, as well as internal risk assessments and strategic considerations, several companies have taken actions. Some corporations have divested, for example, KLP from Caterpillar, Irish Strategic Investment Fund from 6 Israeli companies, and AXA from 5 Israeli banks and Elbit systems, or have withdrawn their operation from the Israeli market, as have Veolia, CRH, General Mills, G4S, Yokohama, and Pret-a-Manger, and Ben & Jerry's continues to fight to implement its decision to withdraw sales to colonies against efforts of its parent company Unilever. In the sports sector, sustained advocacy led Adidas, Puma, and Ariane to end their sponsorship of the Israeli Football Association. 34. In 2016, the Human Rights Council adopted Resolution AHRC Res 3136, pursuant to which the Office of the High Commissioner for Human Rights established a database in 2020, UN database, listing business enterprises that have directly and indirectly enabled, facilitated, and profited from the construction and growth of the settlements, identifying 10 specific types of activities. Its most recent iteration, updated in 2023, lists 97 companies. While it doesn't cover the full gamut of relevant activities, the database captures critical components of the complex matrix of corporate entities involved in the displacement and replacement of the Palestinians. 3.2 Seismic Shift International Court Proceedings. 3.5 Recent legal developments concerning the OPT have significantly reshaped the assessment of corporate responsibility and potential liability. 36. Most significant is the ICJ's advisory opinion on 19 July 2024, which addressed the legality of Israel's very presence in the OPT. The court declared the prolonged presence of Israeli in the whole of the territory, including its colony regime, composed of its military presence, settlements, associated infrastructures, and control of Palestinian natural resources, as illegal in its entirety on the basis of sustained violations of 2 peremptory norms of international law: the right of self-determination of the Palestinian people and the prohibition on the acquisition of territory by force, annexation. The court also recognized, among others, the violation of non-derogable norm prohibiting racial segregation and apartheid. 37. The ICJ's finding of a violation of the prohibition on the use of force effectively qualifies the occupation as an act of aggression. Consequently, any dealings that support or sustain the occupation and its associated apparatus may amount to complicity in an international crime under the Rome Statute. While Israel, as the de facto occupying power, remains bound by international humanitarian law, the illegality of the occupation means all administrative and military actions it undertakes in the OPT, from controlling visas, permits, and movement to incarceration and economic regulation, lack lawful authority under international law and should be considered invalid. 38. Second, the recognition by the ICJ of the violation of the right to self-determination in turn informs the interpretation of all human rights and other legal obligations that flow therefrom. As the court said, the right to self-determination is the most fundamental and existential right for all human beings, as it pertains to the inherent capability of a people to exist and determine themselves as a people in a given territory, free from foreign control and occupation. Without this right, a people are unable to exercise control over their lives and the resources in the territory recognized under international law as their own. 39. On the basis of the ICJ's advisory opinion, the UN General Assembly demanded that Israel bring to an end its unlawful presence in the OPT by 17 September 2025. Until that happens, states must not provide aid or assistance or enter into economic or trade dealings, and must take steps to prevent trade or investment relations that would assist in maintaining the illegal situation created by Israel in the OPT. It should be emphasized that the failure of states to act on the ICJ ruling does not absolve corporate entities of their responsibilities under international law and the UNGPs.